Hello everyone, my name is Thomas Margoni and I'm a senior lecturer in intellectual property and internet law at the School of Law, University of Glasgow. The title of my presentation today is Copyright and Text and Data Mining, a European Perspective. And over the next 20 minutes or so, I plan to offer you a brief but hopefully comprehensive overview of how EU copyright law regulates text and data mining. First of all, some key points. The main legislative instrument that regulates text and data mining EU-wide is the recent Directive 2019-790 on copyright and related rights in the digital single market. A directive that has the ambitious goal of making EU copyright law fit for the digital age. It is a complex legislative instrument made of 32 articles and 86 recitals. It is also a EU directive, so it is important to keep in mind that it needs to be transposed into national law by EU member states in order to become effective. Member states have 24 months of time to implement it, meaning until June 2021. The directive does many things, introduces many changes to EU copyright law. For the topic of today, text and data mining, the two articles that are most important are Article 3 and Article 4. They introduce two mandatory exceptions for text and data mining. The directive, for those of you who are interested in the field of text and data mining and EU law, does other two important things that, to those of you who are less familiar with the field could sound very technical. But I just mentioned them for the sake of completeness. It clarifies that Article 5.1 of a different directive, the 2001 InfoSoc Directive, which establishes a mandatory exception for certain acts of temporary reproduction, continues to apply to the field of text and data mining. It also clarifies that broader national text and data mining exceptions adopted in compliance with other directives will still be available. So what I will do over the next few slides is to offer a brief overview of the main points that I think it's important to understand with regard to Article 3 and 4. I have first two slides summarizing them, and then I have another 5 or 6 slides where these points are discussed a bit more in detail. Some points are self-explanatory, whereas other points, as you will see, require me to give you a bit more details. I should also say that I think it will be useful, so I do it, for me to include the reference to some national text and data mining exception to show you that in the EU law we still have this we could call it duality between the EU copyright law that is being created at the EU level and the EU copyright law that is being created at the national level, so to speak, and how they talk to each other. So I'll be making reference to Section 29A of the UK Copyright Design and Patent Act, which back in 2014 has introduced a text and data mining exception. So the point that I will discuss with you, and we'll see them now very briefly, are the definition of text and data mining, the scope of the exception, the beneficiaries that these exceptions will be available to, what is the relationship to contract, or this perhaps it's a concept that is more familiar to European scholars, but can I limit an exception through a contract? The relationship to technology. Regardless of whether I can do that, I can limit the operation of a certain exception through contract. Can I do it as well or in a different way through technology, for example, through digital right management or technological protection measures? So, first of all, the definition. Text and data mining is defined by Article 2 of the European Directive as any automated analytical technique aiming to analyze text and data in a digital form in order to generate information such as patterns, trends, and correlations, or more succinctly, under the UK CDPA, any computational analysis of anything recorded in the work. No big issues at the moment with the definitions. They seem to be both broad enough to capture most, if not all, of the uses that we do with text and data mining. If anything, but that could be seen as somehow implicit in legal rules, especially at the statutory level. They don't really give away the importance of these activities, but we can find some of this, for example, the relationship to fundamental rights in the preamble, at least of the European law. So we could say that we are, we could express a positive evaluation of this aspect. More problematic is the second point, the scope. These exceptions, all of them, so the Article 3 and Article 4, and we will see the difference in a moment, of the EU Directive and Section 29A of the UK CDPA, all of them are exceptions only to the right of reproduction. So other rights that belong to the concept of copyright, such as the right of redistribution or communication to the public, or the right to create adaptations or derivative works, are not covered by these exceptions. What does this mean? Well, it can mean many things, but just to give you an example, it means that if the result of a text and data mining activity, let's imagine machine learning applied to natural language processing. So we are teaching an algorithm how a language is spoken. We have the machine learning algorithm, and this machine learning algorithm creates a file, trains a model, and in this model we have syntactic and semantic relationships among words of the English language. Well, if this trained model contains 11 consecutive words, this has been technically wrongly become the EU threshold for copyright infringement. Well, in this case, we could have a problem in the sense that that model could be created because in order to create it, we need we need to make reproductions, and therefore an exception to the right of reproduction is helpful. But if we want to redistribute that model, to load it in our computers or personal assistants or cell phones, or distribute it online, well, all these activities are not excused by the exception, because the exception is only an exception to the right of reproduction and not to these other rights. Now, for the sake of clarity and correctness, I should say that 11 consecutive words is not in itself the threshold for copyright infringement in the EU. The threshold is whether those 11 consecutive words are, and this is the test, the author's own intellectual creation, whereby the authors put their personality into the work through free and creative choices. But the Court of Justice of the EU, in a number of cases, the most famous is Infopac, clarified that it cannot be excluded that 11 consecutive words correspond to this threshold. So we could have a problem there. Similarly, because this exception is only an exception to the right of reproduction and not to the right of, say, adaptation, to create thumbnails of, let's say, web pages would certainly not be covered by the text and data mining exception. So we see here quite important limitations to how these exceptions operate, and I'm sure that if you already have listened to my colleague analyzing how the U.S. law regulates these aspects, or as soon as you do, you will notice important differences here. Beneficiaries is another point that may create some concern. And here the situation is even more complex in the sense that each of these three exceptions approach the aspect of beneficiaries differently. So in the case of Article 3, the exception is only available to research organizations for research purposes. In the case of Section 29A CDPA, the exceptions is only available to non-commercial research. And in the case of Article 4 of the EU directive, the beneficiaries are potentially everyone for any purpose, but with important limitation that is covered more thoroughly in the next slide, that right holders can opt out. Now, this is quite problematic for a number of reasons, but mostly because, and depending on the specific exception, so to a different degrees, however, individuals, micro and small and medium enterprises, industries, professional creators, amateurs, all these people are tendentially excluded from benefiting from these exceptions. And likewise, purposes other than research, such as journalism, criticism, review, are likewise not covered. So we can see here another major limitation of how these exceptions to copyright can help text and data miners. Now, another important aspect here is that all these exceptions require lawful access to the content to be mined. So they only operate as long as the beneficiary has lawful access. Here again, it can be very technical, but it's important to keep in mind that these exceptions, all of them, clarify that a contract limiting the possibility to perform text and data mining is not enforceable. This is very important because this is not always the case under EU copyright law. Many exceptions and limitations can be limited by contract, so it is very important to clarify at the outset that any contract that limits the text and data mining exception is not enforceable. This is very good. However, and I'll try to explain this as clearly as I can, but I understand it may be a bit counterintuitive. If the same condition, if the same order, so exception not available, instead of being expressed through a contractual language, let's say, is expressed through a technological one, a few lines of code, think of a technological protection measure or DRM, then this limitation that would have been unenforceable if expressed through human or a legal code suddenly is not unenforceable anymore. Does it mean that technological protection measures or technological measures in general can effectively limit the exception? Yes, but there are a number of aspects to take into account, and there are ways through which users could complain against this specific situation. Again, it gets a bit complex and depends on how to implement this. It's a matter of national law usually, so I won't again enter into the details, but it's important to understand here that technological protection measures could, as a matter of fact, threat the operativity of these exceptions. Integrity measures, so those measures that right holders could adopt in order to preserve the stability and safety of their networks, are also possible. So, for example, there are ways through which you can limit how much data a certain IP could download, because otherwise this would compromise the stability of your network, of your servers. Then if such a measure was put in place, that would be a legitimate measure. However, it should be put in place only for the sake of the stability and security of the network, not as a way to circumvent the operativity of the exception for other reasons. Storage is a very important aspect, which is only present in the newer EU laws in Article 3 and 4. It's not present in the older UK exception. And basically, the Article 3 and Article 4 clarifies that copies of protected works made under the above conditions can be retained for as long as necessary for text and data mining purposes in the case of Article 4, or for scientific research and verification of results with appropriate level of security for Article 3. This is a very important principle because it allows for the verifiability of how text and data mining is being performed. And especially from a scientific point of view, we know how crucial the verifiability and replicability of certain experiment and the creation of certain knowledge and results is. So this is a very important aspect, which is found only in Article 3 and 4 of the EU law. So far, I hope I gave you a brief, comprehensive, and also clear overview of how EU copyright law regulates text and data mining, meaning when it is possible to perform text and data mining activities on copyright protected content, and when not, and under which conditions. In the next couple of slides, before I conclude, I'd like to perhaps give you or reflect together with you on what are the implications. What does it mean, what I told you? Is just a purely technical aspect of a certain technology that, you know, it's being used nowadays, or it's something somehow more important, because text and data mining is a technique, but is a technique that lies at the foundations of how knowledge in 2020 is produced, and therefore basically we are establishing whether right holders can control derivative markets, such as those that relate to the extraction of knowledge from protected works. So I guess that the main question here is whether data, and here I'm only covering non-personal data, is owned. From a copyright point of view, can data be protected? And if it is protected, who is the owner of this data? Well, copyright, both law and especially theory, it's quite clear that principles, facts, data as such are not protected by copyright law. We can find this in most national and international legislations. I cite here some. Other areas of law may offer some form of protection to data as such, but usually in a very specific, in a limited and very specifically identified form. So we have trade secret, but with the requirement of confidentiality and limited remedies. We have contracts, data protection for a certain type of data, but we don't really have a proper, property right protecting data as such. So think that data, raw unstructured data that you collect, in general, it's not protected as such. And this is very important. We will see in a moment why. But let's analyze other cases and forms in which we can find data. So what about data that is contained in a database? Well, EU law offers protection against substantial extraction of data from databases, both original and non-original, therefore effectively protecting certain kind of data. And the clarification here would be only collected, obtained, verified, or presented data, but not created data. And this is called the sui generis database right. So this right is not present in the US, is almost only present in the EU, and in this case we could say that data becomes protected. Not all data, only a substantial amount, and only qualifying data. That is to say, data that is collected in a qualifying database, so not data that is not contained in a database, and only when making this database and collecting this data required a substantial investment of time or effort. Again, a bit complicated, but I think here it's important to understand the broader picture. What if when the data is not contained in a database but in a work? Well, in theory, here the data in itself is not protected because of what we saw in not the previous slide, the one before. Data as such, information, factual information, all these are not protected. So one should say, well, if they are contained in work, they should remain unprotected. So in the case of, let's say, a Harry Potter novel, obviously the character, the original contribution of the author, what happens, the storyline, the narrative, all these elements are protected. But is the statistical information about English language that can be extracted from the novel protected? Well, copyright theory and international copyright tell us no. However, it turns out that unless we do this probably manually and keeping pages and pages and pages, million of pages of this information in our mind, as long as we do this on a computer, this becomes de facto, or perhaps even de jure, prohibited. Why? Because we need to make a copy, right? Computers, and even more so text and data mining, digital technologies are about copies. You make copies all the time, even if these copies are temporary, transient, accidental, partial, or indirect. You make copies, and especially under EU copyright law, all these copies are protected. So, is data owned, and why does it matter? Well, the answer to the first question is that despite what copyright theory might suggest, certainly under EU copyright law, data is very, very, very often protected. In the case of text and data mining, this means that in order to extract knowledge, and we know that TDM techniques often allows us to extract new knowledge or unknown knowledge, or discover new and unexpected relationship patterns and line of reasoning from all data sometimes. Well, we have to ask ourselves whether from a public policy point of view, in terms of certainly scientific research, but also economic growth, cultural development, etc., whether we want this situation. We want to say, well, if you have written a novel, for how great the novel it is, you certainly deserve protection, but how far this protection should go? No one puts under discussion the fact that, again, Harry Potter or any other character as such should be protected, that if you print copies of the book, well, that should be subject to the authorization of the right holder, and etc., etc. This is not out this is completely out of the picture here. What we're saying here is, can I use that information not as a novel but as data in order to create new knowledge in a way that does not impact on the economic and also moral interest of the author, by implementing so restrictive text and data mining exceptions as in the EU. We are saying, well, yes, in this case, right holder, the owners of the original material, have a right to control this secondary market. However, I don't think that this kind of awareness was present in the EU legislature when they passed these exceptions. They were not aware of the fact that by creating these rules, you're actually defining the lines of a development of technology in the EU in the decades to come, not just years, because here we are basically regulating artificial intelligence. We are saying that it is not tech companies, it is not researchers, but it is the owners of huge databases of literary and audiovisual works who can determine the development of science. And I'm not sure that the option that the EU has opted for has been so well analyzed in a way that really explains the deepest implications of this decision. Well, I hope that the presentation was clear. I hope that I have achieved my goals, which, if you remember, if you're still following me, were to offer you a brief but hopefully comprehensive and especially clear overview of how EU law regulates text and data mining. Here you can find a few links to a number of projects, repositories, or papers that may help you in this field if you're interested. Obviously, don't hesitate to contact me by email or during the following discussion. I would be very happy to answer any of your questions.